Is Judge Brian Lambert. To my left is Judge Joe Boatwright. We have 3 cases on the docket this morning, and they're all civil cases. We have 1 cross appeal. So typically for the appellant, we reserve 5 minutes for rebuttal. For the cross appeal, let us know what you want for that as well, if you want any rebuttal time. And we've got, yes, we do have our lights set up, right?
Yes, Your Honor.
Okay. So it's not very difficult. Green means you're good, you're still got plenty of time. Yellow, if you're the appellant or cross appellant, you're into your rebuttal time. And when it hits red, it's time to stop. So your 20 minutes on the clock is your full time. You don't get any extra time. So our first case this morning is case 23-3183, Michael Gabor versus Remington Lodging and Hospitality. So if y'all come forward. And pleased to have everybody here. If anybody has something that might make noise like a cell phone, it's guaranteed to go off right in the middle of somebody's really gripping argument. So please put it on silent or vibrate or whatever it is that you have so it won't ring too loudly. Okay, counsel. How about for rebuttal times? 5 minutes work for you?
5 minutes, perfect.
Okay, great. You may proceed.
Thank you, Your Honors, and may it please the Court. My name is Jonathan Martin, and I represent the appellant, Michael Gabor. This Court should reverse the trial court's order denying Gabor's additor and new trial motion because the $0 damage awards that were rendered by the verdict are inadequate as a matter of law when compared to the undisputed evidence that Mr. Gabor suffered at least some damage as to each category of damages. And as to the cross appeal, this court should affirm the trial court's order denying the Remington directed verdict motion because competent substantial evidence supports the jury's finding that Remington's management of the hotel that night foreseeably and unreasonably created a risk of harm to Gabor that resulted in his damages. Starting first, I'd like to begin with the cross appeal issue. And so the first half of the analysis focuses on the Petrick, Clooney, and Jones decision where the framework is essentially whether the additional negligence claim is duplicative of the vicarious liability claim against the same employer, or if it provides for an additional liability. And so although this case is not perfectly in line with any of those decisions, the key is the framework, which is whether it is duplicative or not. And here, for the following reasons, it is clearly not duplicative, which happens to be the same reasons as in the Petrick decision, which is that here the negligent supervision claim is specifically focused on not Henderson, but specifically the negligence of the managers. So putting this manager who is inexperienced, such as Harris, in charge, her poor decisions, such as telling Gabor that he had to remain in the hotel and ordering...
Counsel, wasn't that an agreement that the husband, wife, police, and the management came to?
Right, so conflicting evidence was presented to the jury as to whether or not Gabor was being directly ordered by Harris specifically, or if the police had...
Counsel, y'all have alleged that it was negligent conduct for the manager of the hotel to suggest that he stay there or to even permit him to stay there. Isn't that one of your claims?
I believe there was alternative theories presented to the jury, but ultimately we did present to the jury that it was negligent to tell him that he could not leave the hotel. And because of that competent substantial evidence, the jury was free to conclude that it was Harris and the management that ordered Gabor that he had to leave. And then, of course, it's undisputed that the other manager, Doran, did specifically order Henderson to make sure that Gabor did not leave his room.
And so your claims were negligent supervision. Apparently the claims that you prevailed on, at least on the 20 of the verdict, was there was negligent supervision and negligent training, right?
Correct.
You pled negligent retention, negligent hiring, but those fell by the wayside.
Right.
Okay, so who did the negligent training and the negligent supervising?
So it is sort of a combination because Remington was negligent in training Harris because she wasn't qualified to perform the role as the manager. And so the negligent training and supervision would be the hotel management company's negligence in preparing Harris to be ready to do this. And so then she was then foreseeably negligent in the poor choices that she made.
Regarding Henderson.
Ultimately regarding Henderson, but
So the actual actors on the scene, if I understand, is the general manager and then the front desk manager. They're the ones who were the employees of Remington, who you believe the evidence showed acted negligently regarding their training or supervision of Henderson, who was found not to be negligent. Am I following?
yes,
correct?
that's another way to say it, and that's
Is that an incorrect way of saying
No,
or analyzing it?
So I think it's because we didn't limit our theory to just her specific supervision and how she acted and Doran acted toward Henderson, because it also involved the management company itself even choosing to allow Harris to be in this position in the first place, given her inexperience, and there was expert testimony to that effect, that even putting her in that position foreseeably led to a dangerous situation that ultimately resulted in Gabor's harm. And so like in the Petrick decision, the supervisor was the one that was targeted with the negligent supervision claim because of or hiring claim for failing to do a proper background check, etc., on the driver. And so ultimately the underlying tortfeasor, of course, caused the damage, but because the negligence was different. And so here, for example, it is not just Henderson's decisions and conduct that's imputed, it's specifically Remington's direct negligence for choosing an inexperienced manager to run the hotel that night, and then by extension, her poor decisions ordering Gabor to stay in the hotel, and her decisions, and Doran's decisions ordering Henderson to stop Gabor. And so the point is, that's additional liability, that's separate tortious actions, and that's why, like in Petrick, it would be appropriate to allow the claim to proceed because it's not duplicative. Now, the briefs and the cross-appeal issues also discuss the elements of negligent supervision and whether or not there's competent substantial evidence to support those, and there is. And so going through each of the items that the briefing tackles, the employer Remington here was aware of the unfitness of Harris because, as the evidence showed, she was unqualified to do this, and therefore they failed to properly reassign her to a proper role, such as the catering and party planning that she was qualified for. Gabor and even Henderson, for that matter, were under the control or supervision of Harris under the facts of this case because Harris was ordering Gabor to stay in the hotel, and of course their manager Doran was ordering Henderson to ensure that Gabor did not leave the hotel. The employer Remington knew the propensity of Harris to commit this tort because negligent supervision is itself a tort that a supervisor can commit. And our entire theory was that it should have known that she would have committed the tort of negligent supervision given her inexperience. Therefore, the employer was aware of her propensity to negligently manage a hotel. And then finally, of course, Remington was in control of Harris. They were her employer and ordered her to manage the hotel that night. And so the final element, whether Harris was working in or outside of her employment at the time, there is more than competent substantial evidence to support that she was working outside the scope of her employment because she was essentially acting as a warden to imprison Mr. Gabor, which of course is not what a hotel manager does. There was expert testimony and testimony from Remington's own employees that she had no right to order Gabor to stay in the hotel, that there was no duty or no responsibility to order Henderson, a maintenance employee, to keep him in the hotel. And so the jury could conclude, and there was competent substantial evidence to support, a finding as to all of the elements, including whether she was working outside the scope of her employment. And for all those reasons, this court should affirm as to the cross-appeal issue. As to the main appeal, starting first with the past pain and suffering damages, of which was a $0 award like all the others that are being contested, it is well established Florida law that if there is at least some damage that is undisputed as to past pain and suffering, a $0 award is inadequate as a matter of law. And of course, in this case, we have a situation where even though the extent of the beating and the extent of the damage that Gabor received was hotly contested at trial, it was undisputed that Gabor was punched twice in the face by Henderson, wrestled to the ground, and held there for a number of minutes. Indisputably, getting punched in the face twice causes some amount of bodily injury and pain and suffering. For that reason alone, of course there was more evidence that Gabor presented, but for that reason alone, because of the $0 verdict that we have, and that's what makes this case special. Because if they would have awarded Gabor $2,000, $200, or even a nominal amount, the case law makes it much more difficult for a reversal.
I'm going to ask, do you agree that if we disagree with your view on the cross appeal, that your claim on the direct appeal is moot?
Correct.
And as to the insufficiency of the damages, the jury made their finding that there was no future medical expense award. Do you agree that it would be consistent with the verdict to not award future pain and suffering? I mean, it seems like your additor claim or your new trial would be limited to, I got X number, $50,000, $60,000 worth of medical expenses related to this altercation. There had to be some pain and suffering related to that for me to incur those kind of damages that the jury awarded as being causally related. Therefore, I should get some award for past pain and suffering, the past intangible damages.
We're arguing both that we have to get a new trial on the damages issue of the past pain and suffering for those reasons, but also we are arguing that the future damages also require a new trial. And I can get into that. So with the past lost wages, future medical expenses, and future pain and suffering, the key is what this court can glean from the past medical award of medical damages.
Can we glean from the verdict that whatever injuries that your client suffered as a result of this altercation with Mr. Henderson, that the jury, by its verdict, decided that he wasn't suffering anymore, he doesn't need any future medical care, and therefore he doesn't have any future pain and suffering related to this incident? Isn't that a fair take from the verdict? It might not be the take you like, but isn't that a take that you need to come from the verdict?
The answer is actually absolutely yes, and that itself
That's the
shows...
first time I said that to me, right?
No, that absolutely shows error for the following reasons. So, what can be gleaned from the past pain award is that they necessarily concluded that he did suffer a traumatic brain injury from the hotel incident, but what's key is that the evidence of the permanence of that traumatic brain injury went unrebutted. There's nothing in the record to give the basis to reject that expert opinion, and of course in Florida law...
Are you saying no expert on behalf of defendants said there was no brain injury from this incident?
They absolutely said there was no brain injury at all, but never did they ever say that if there was a brain injury, that it wasn't permanent. The point is that step one is that the jury necessarily found that Gabor did suffer a traumatic brain injury from the hotel incident because of the award of past medical damages. That's step one. And then step two is that the evidence of permanency specifically was unrebutted. Therefore, even if the jury did, which would be inappropriate, with the other awards determine, oh no, he healed, that would be inappropriate because that would be rejecting the unrebutted evidence of permanency, which a jury cannot do. So even if the court does glean from those awards that they rejected the causation issue as to those awards, but not the other award, that would be inappropriate because they would necessarily then have to reject the unrebutted evidence of permanency.
I thought there was testimony from the defense experts that he didn't suffer any injury. I mean, why can't the jury say, okay, the guy was Mr. Gabor was in an altercation, he went and got medical care and treatment, that's a reasonable thing to do after the incident or any accident, anything that happens. But at the end of the day, he doesn't need any more, he's better. I don't mean that in any kind of dismissive. The jury reached a conclusion, I guess you can, from the verdict, that you got to get your medical bills paid. I get what your past pain and suffering, I get that argument, but going forward from that point, they accepted the defense's expert testimony, and why can't they do that?
The key is because the past medical expenses are specifically for treatment of a traumatic brain injury, not just I was hurt and I have a headache or I have bruises. And so because of that, the only way to possibly award him those damages is to find that he had a traumatic brain injury. But once you do that, because
It's
it's
to find
permanent,
that he was being treated for whatever he was injured about. I don't know that it necessarily means he had a traumatic brain injury by awarding medical expenses.
well, for example, like treating him for all the cognitive difficulties and the exams on his brain, et cetera, and the medication because of the cognitive difficulties, that's all exclusively and solely to treat the traumatic brain injury. So the jury cannot provide him with those damages, those medical expenses, unless he actually has the traumatic brain injury, because otherwise it's not a reasonable treatment. And so that means...
Couldn't you likewise say, since the jury found there was no future medicals, they found he had no brain injury and it was error for them to award the other money?
But see, that's my point. Yes, it can be gleaned from the other awards that they found that he didn't have the traumatic brain injury, but the opposite is said with the past medical expenses, and the key is the permanency issue. Because the only way to glean from the future award that he didn't suffer a traumatic brain injury from the accident is to reject the unrebutted evidence of permanency, and the jury can't do that. So yes, they can be gleaned, and that shows error by itself. And I see that I'm about to get to my rebuttal time, so unless there are any further questions.
Thank you very much. Counsel for Remington. Do you want surrebuttal time or rebuttal time or?
Yes, please, Your Honor. 5 minutes for cross rebuttal.
Okay. You may proceed.
May it please the court. Nicholas Consalvo on behalf of Applebee's Cross Appellants, Remington Lodging and Hospitality, and Robert Henderson. As in regard to plaintiff's initial appeal, the trial court did not abuse its discretion in denying plaintiff's motion for new trial or adder because the verdict was not inconsistent, inadequate, or against the manifest weight of the evidence. There was significant conflicting evidence presented on the issues of causation, permanency, and damages, and the verdict was supported by the evidence.
Well, I mean, as to the future, I mean, the jury awarded no future medical expenses, so I think an inference from that verdict is they decided that he was better. Again, I don't mean to be dismissive by that term. But they didn't think that he needed any future care, and therefore he wasn't suffering any injury anymore. But as to the past pain and suffering, isn't that logically inconsistent, or using your opponent's term as a matter of law, if the jury awards $50,000, $60,000 of medical expenses, how does the person not have any pain and suffering, any dollar amount of pain and suffering whatsoever, despite incurring such a significant amount of medical expenses?
It's not inconsistent as a matter of law, Your Honor. Under Florida law, a verdict that fails to award pain and suffering damages, despite awarding some medical expenses for the claimed injuries, is neither inconsistent nor inadequate unless the evidence of intangible damages is entirely undisputed.
Did they award all past medical expenses?
They did, Your Honor. And the past medical expenses were primarily for seeking treatment and evaluation after the injury. It was the initial.
What was the amount of the medicals?
The past medicals was $281,000.
Right. And your position is getting smacked in the face hard enough to get two black eyes doesn't hurt a bit. I mean, that's got to be your position. And, trust me, I was a defense lawyer back in the day, but
As was I.
getting hit in the face hard enough to leave two black eyes, that hurts. How can it not hurt? How can it not cause pain? I mean,
How can that be awardable pain and suffering?
even if it's $10, $100, $1,000, whatever it is, it's not nothing. Nobody feels nothing when they get two black eyes.
It's the plaintiff's burden to allege and establish that at trial. And what they allege as their past pain and suffering damages, which they stated in their closing argument and in their motion for new trial and adder, was that the pain was suffering from cracking headaches, requiring narcotic medication, suffering was worrying about when the next headache is going to come, worrying about greater risk.
Couldn't that have come from being punched in the face twice?
It could have, but there was conflicting evidence on his long, extensive history of chronic headaches that he treated with
So
narcotic.
if I understand what you're saying, plaintiff did not say, hey, jury, I got hit in the face, this hurt some, give me some money. They never made that claim to the jury. Is that what you're saying?
That's correct, Your Honor. They asked for $1.6 million in past pain and suffering damages. And it was related to the past pain and suffering that they described as 10 years worth of headaches and chronic injuries related to the alleged traumatic brain
They
injury.
didn't lump in right while he's getting punched. They didn't ask for that money for basically the black eye.
Not specifically below, that was something that was raised in the brief as something
Do
that
they have to
should
say that? I mean, I have pain and suffering from this incident. Do they have to say, and this part of my face hurt, or this hurt, and then my back of my head? I mean, I guess following up what the chief is talking about is, all right, it had to have hurt somewhat. You know, and I guess we all have pain thresholds, but Mr. Gabor says, this is what happened to me, it hurt, I have suffered pain and injury from this, and I have received medical expenses to treat me. I mean, if his pain was unrelated to this incident, then I don't know why he would have gotten his medical expenses paid. I mean, it would seem to me that he would have incurred these medical expenses irrespective of whether he had the altercation with Mr. Henderson. I don't think that's your position, or that's supported by the.
I believe that's more related to the cross appeal, which I'll get to, about why the fact that they found Henderson 0% negligent was an issue in this case. But
Well, it was a winning issue for you, so I'm not sure you want to re-raise that.
correct.
As I see you say on a regular basis, use your time as you deem appropriate, I guess.
That issue is not Henderson's liability.
Yeah, you won. In fact, you represent Mr. Henderson, so you ought to be happy.
Correct, yes. But in terms of the past pain and suffering damages, the credibility and the evidence was disputed as to what his past pain and suffering was, whether it was headaches, whether that was related to chronic pre-existing psychological issues. And the most significant issues were that his credibility was significantly impeached in that issue during this trial. Pretty much every statement of his account of the incident, his disclosures to his treating providers, all of that, there was significant conflicting evidence and impeachment evidence.
Well, I mean, it seems like he was impeached, or the jury didn't find him that credible because, you know, a fair reading of the verdict is they believe Mr. Henderson's view of why the altercation occurred, right?
Correct.
Is that,
And Henderson,
wrong?
correct. And Henderson's account of the altercation was significantly different.
Right,
It was
so
that he took-
I get what I'm getting to. All right, so they found that Mr. Gabor was not as credible about certain things, but at some point, they did award him all of his medical expenses, the $281,000, and then it was reduced down, you know, because he was found 80% at fault, so the net was the 50 or 60 number that I've been using. But, yeah, so all of his medical expenses that he says were related to this accident, whatever they thought about his other issues about the causation of the fight, they found that it was related to this and it was awardable.
Correct.
And you're not, are you suggesting, I don't remember, are you briefing that we should set aside that award?
No, Your Honor. No,
Okay.
Your Honor. And the past medical expenses is based on medical records and billing that was presented and was not.
Because Mr. Gabor went there and said, this is what happened to me and I would like to be treated, and he was treated and it got up to $281,000 and the jury gave him every penny of that.
Correct, Your Honor. But unlike past medical expenses where the amount can be fixed and shown in records, the only way to establish future or past pain and suffering is based on the plaintiff's subjective complaints of pain and suffering. And that necessarily invokes whether the jury weighed and found his testimony credible.
So when he said, I'm hurt because I got beat up and went to the doctors and I have $281,000 worth of bills, the jury could say, no, you actually have no pain from that, and even though you incurred the $281,000 of bills?
They can. If there's conflicting evidence on.
But is there conflicting evidence that he had no pain?
There's evidence that the jury found his testimony not credible. They did not believe anything that he testified to as to his subjective complaints to treating providers, as to his subjective complaints of the pain he suffered from the accident, how the accident occurred, the extent to which he was punched. That was a significant issue where he said that Henderson was the one who initiated the fight and started and punched him multiple times, and it was the worst pain ever. Henderson's account was significantly different, that he got attacked first.
Well,
He threw
but that's
one-
liability. I mean, he was still, whoever was fault, the jury found in your favor on the negligence claim against Mr. Henderson individually, but
Correct.
the man still had some pain. I guess I'm having a disconnect here saying, I got beat up, I went to the doctor, I get awarded all my medical bills, but the jury could say that essentially I have no pain whatsoever. I reject your claim that I suffered any pain when this, I mean, wasn't Mr. Henderson a full contact karate boxer or something like that? Or
I don't remember exactly what it was. Yes, there was-
Some kind of martial art.
He wasn't just Meter Edwards wandering around. He was a guy who was actually, a guy who knew how to, he was a fighter. I mean, as part of a hobby or profession or whatever. I mean, so you would think that that would be a guy who knew how to inflict pain if he had to get engaged in an altercation.
And those were all issues for the jury to weigh and consider, and that's why the standard review on this is.
I get all that, but I mean, if somebody loses their hand and you come in and say, well, he has no permanent injury because, you still got your other hand, the fact that he may not be a credible person, he still has something happen to him. You can't say, well, you can't get any award for losing your hand because nobody believes you otherwise.
Answer to this, if we don't go your way on the cross appeal, could we remand simply for the trial court to reconsider the motion for additor rather than holding a new trial on damages?
Possibly, Your Honor. The other issue with that is they did not specify what amount of past pain and suffering they believed was appropriated in the motion for additor. It simply said based on the reasonable evidence presented. So the trial court's already determined that it agreed with the jury that it wasn't going to disturb the jury's verdict, that there was no awardable damages, nominal or otherwise.
So let me ask that, so if it goes to follow what the chief said, so if we remand for an editor and the trial judge have heard the case, and well, I think the reasonable amount of pain for the past pain and suffering is 10 grand, is that an appealable thing anymore, or is that's a discretionary, I mean, I guess everything's, we get appeals from prisoners all the time, I guess everything's appealable. I may not have jurisdiction to hear it, that's a different discussion we have amongst panel members sometimes, but.
I'm assuming plaintiff accepts the 10 grand or whatever hypothetical number it is.
I would have to look into that more. I'm not sure if that necessarily would be an appealable issue. That's not something we've agreed.
Talking about your cross appeal?
Yes, Your Honor, please. So on the cross appeal, we believe the trial court erred in denying the motion for directed verdict as to count 1 of the complaint, which alleged direct negligence claims against Remington for negligent supervision.
So the hotel manager had directed Henderson to stay outside the room, and if Gabor came outside, that it was to physically restrain him. Why would the hotel not be negligent in that situation?
Because that's not what a negligent supervision and training claim is. The elements for negligent supervision and training, it's discussed at length in the Axe retirement case, the Fort BCA case from 2016. They give multiple
Even if the
information.
manager said, hey, go beat him up if he comes outside the room?
Now that's a different scenario, because now we get into the issues of whether they were within course and scope of employment. But
Isn't that what's dispositive here?
yes, Your Honor, that is
I mean, the manager, the general manager, and the front desk manager were not sued individually.
correct.
And they could have been. I mean, I'm not saying that they should have been, but I mean, that is a cognizable event to happen in cases. So they could, you could sue the employer, you could sue the supervising employees, and then Mr. Henderson, the subordinate employee.
Correct, Your Honor.
But they didn't do that, so.
They didn't do that.
They didn't sue the 2 managers.
And so,
And it has to be outside, so for Remington to be liable for negligent supervision, negligent training, isn't it the actions of the 2 supervising managers have to be done outside the course and scope of their employment?
that's absolutely.
Otherwise, it's a respondeat superior claim where the negligence of the actual employer is irrelevant. They're responsible for the negligence of their employees acting within the scope of their employment.
That's absolutely correct.
Which is, I understand your view is, whatever they think that the man, I mean, I know your position is all this sort of morphed along in the trial, that all of a sudden it became, oh, it's those two managers who were negligent, by the way, now that we're thinking about it, they were never sued. But let's assume that's on the plate now before us. Anything they did was within the course and scope of their employment. There's no evidence they were outside the course and scope of their employment with Remington.
That's correct, Your Honor.
I mean, it's one thing to say, following what Judge Bogart was saying, one thing to say, okay, Mr. Henderson, if Mr. Gabor takes a step out of his room, I want you to pummel him within an inch of his life. That would probably be outside the course and scope of the manager's employment.
Correct, Your
I
Honor.
would say.
And so, for the argument.
That's not what the evidence was.
Correct, Your Honor. And the argument that counsel made saying that Harris, working outside the course and scope, was acting as a warden.
Was that
That's the first time I've heard that argument.
Today?
Yes, Your Honor. And the other issue with that is, so the underlying action, and the Acts talks about this too, the underlying action of the managers has to be a tort. Negligent super has to be an independent tort by itself, not negligent supervision and training. That's discussed in the third BCA's case in Cardozo, saying negligent training is not, as a matter of law, a distinct theory of liability for damages which can form the basis of a separate award. It has to be an independent tort committed. So if they were alleging that, for example, that Henderson had been outside the course and scope of his employment, then the tort of battery is the underlying tort. The tort of negligent supervision itself cannot be the underlying tort. All they were alleged to do was negligently supervise Henderson, but Henderson's actions were the only underlying tort that was alleged in this case. And going back to the course and scope of employment, Your Honor is correct. It was never raised that the two managers were acting outside. More than that,
Well, it was
they
raised to avoid the direct verdict, it was raised.
correct.
It wasn't the theme when the case started, the trial started.
Correct, Your Honor. And I think the most significant point to that is they alleged that Henderson, in the complaint, because he was the only named employee in the complaint, that Henderson was acting within the course and scope of his employment.
They stipulated.
And so, and we admitted to that. So if you're alleging that the employee who allegedly battered your client during, at this incident, was acting within the course and scope, surely the managers supervised, another step removed, alleged to be supervising him, were also acting.
They're not, your opponent's not disputing that Remington is not liable for the negligent supervision or negligent training of Henderson. That's not their position, I don't believe.
Correct, Your Honor. I'm pointing that out.
And I know what you're saying, but I mean, just so we kind of,
Yeah.
follow along in the train of thought here.
Correct, Your Honor. So yes, those issues were resolved in the motion to strike, which was in part denied, and granted in part, denied in part. But
So I mean, basically, as you understand the verdict, the 20% at fault negligence is because of the negligent supervision or training of the manager, the general manager, and the front desk manager.
correct, that's all they could
That's
find.
the only reason, as a matter of stipulation and jury finding, that there could be any negligence on the part. And I understand why you don't think it should be, it's an incorrect verdict. But those are the only, quote, actors that would cause the negligence to be assessed against Remington, the 20% negligence.
Yes, that's what the jury found, but that's not the
They didn't
basis.
make those findings, they just said you're negligent.
Correct.
The verdict form didn't ask them to make specific negligent supervision, negligent training findings.
Correct. And those claims should never have gone to the jury since there was no underlying tort. And
Right, you
that
think
they
the
were
motion
not
for
found.
corrective verdict should have been granted, and that's what you want us to fix here.
Yes. But I'll reserve the remainder of my time for.
All right.
Your Honors. First, I'd like to start with the cross appeal, since that we were just talking about, and I wanted to address specifically the fact that there is not a case that specifically says that the tort of negligent supervision cannot itself be the tort itself that is going to cause the employer to be liable. Instead, that case was talking about you have to have an independent tort in the specific situation where the negligent supervision is of that same employee.
Well, doesn't the fourth DCA say negligent supervision is simply not the appropriate claim to bring against an employer whose employees are acting within the scope of their duties?
Correct. In general, if you're working in the scope of your duties, in general, correct. You cannot get negligent supervision.
So then translating that to, for them, Remington to be liable regarding the general manager and the front desk manager, if I'm following you, what you're agreeing to, then they had to have acted outside the course and scope of their duties that night when they asked Mr. Henderson to keep an eye on Mr. Gabor, for lack of a better term.
For that claim to proceed, yes. And our position is not that this court is reviewing the record to say, under a de novo review, does this court believe, as the seventh juror, whether she was inside or outside the...
But isn't it de novo review?
No.
A motion, the denial of a motion for directed verdict isn't a de novo review?
That's a de novo review. However, whether the verdict is supported by sufficient evidence to meet all of its elements is competent substantial
No, I
evidence.
agree, but I mean, their appeal is the trial court erred as a matter of law in denying the motion for their motion for directed verdict and their post-verdict motion for directed verdict.
Right, and so
So we look at that ruling by the trial judge, de novo.
de novo. And then that trial judge determined that based on the evidence before the jury, there's competent substantial evidence to find that she was working outside of the course and scope of her employment, which is ultimately...
Are we just talking about the front desk manager now?
So it would be both of them, because in this situation, the ordering of Gabor that you must stay in your room and you can't leave, and then also ordering Henderson, go make sure you can't leave the hotel room, so Harris and Doran, both of them performed conduct that is essentially making him a prisoner in the hotel. And in general, even if you don't use the flowery language of being a warden, the point is a hotel manager's duties does not involve forcing the guest to
Is there a
remain...
claim for false arrest that was dropped?
False
Yes.
imprisonment.
False
Yep.
imprisonment, sorry.
False imprisonment, correct. However, that doesn't change the fact that under the facts of this case, competent substantial evidence exists to show that forcing someone to stay in a hotel room and ordering your maintenance employee to ensure that that guest stays there is not even close to being within the scope of a manager's employment. And the only other additional thing I had on that one, is that, and this is a strange nuance, but as the Jones case discussed, you can bring a negligent supervision claim against the supervisor specifically, even if she is working within the course and scope of her employment.
Correct.
And then you can tag from vicarious liability the employer through that way. And that sort of highlights why it's not duplicative when you just bring the claim against the employer when the employee is working outside.
Well, I mean, the Jones case, as you say, is a claim of negligent training, supervision against the supervisor individually as opposed to the corporate employer, does not depend upon whether the subordinate's employee's actions were outside the scope of employment. So yeah, theoretically, you could have sued, not theoretically, I guess if you choose, you could have sued the managers, and then what Jones says is that it doesn't matter whether it's outside scope. But they had that verbiage, and they actually highlighted in their opinion, as opposed to the corporate employer, which seems to suggest, supremacy of the text is always a famous stuff we talk about nowadays, but if you look at the words of that opinion, it seems to suggest that the corporate employer is treated differently, and it has to be outside the scope of employment. But I guess your argument is they were acting outside the scope of employment?
Correct. And if
Do you agree that would be the only basis to save your claim? Save your verdict on the negligence?
So the answer is yes, however, I will give you a quick alternative theory. So technically, the verdict form was just the general negligence verdict form, and during the directed verdict argument, counsel for Gabor did argue that they could be held liable even if they were under general principles of premises liability. And so because of the general nature of the verdict form and the general instructions to the jury, technically speaking, them deciding to put a manager that was inexperienced in charge was simply unreasonable and led to the harm. That's just basic negligence. And their decision-making with the management created a dangerous situation that day, which is premises liability, neither of which have any issues with the elements of those. So that would be the
Lower
answer.
pled.
We did plead the premises liability, and we did plead general negligence. So there's no pleading issue.
All right, thank you.
Thank you, Your Honor.
Thank you, Your Honors. There absolutely is a pleading issue. They did not plead any claims against the two managers individually. The only employee named in the complaint was Henderson. That was it. All of the direct negligence claims are against the corporate employer, which is exactly the situation that Jones was distinguishing between, and the situation that Petrick ultimately distinguished between. Because in Petrick, the same thing happened.
That's
where-
his best case, isn't it, Patrick?
That's the case they relied on, and that the trial court relied on in,
But there was an intertwining of the causes of action asserted in that. Wasn't that what the problem was that I feel?
no, not necessarily, Your Honor. The difference in Petrick was pretty much the same thing in Jones, where there was two counts, or sorry, excuse me, there was three counts. It was an auto accident. The plaintiff sued the truck driver who he got in the accident with, the driver's employer for vicarious liability, and then both the corporate employer and the individual employee, the supervisor who had hired the driver for negligent hiring. And the court in Petrick came back and said it was improper to grant directed verdict on the third count, because the third count imposed, if proven, imposed additional liability on a defendant not named in either of the other two counts. And it was also an issue of, there was a punitive damages claim in that third count that was not in either of the other two counts, so there was a different theory of damages, and there was a different defendant in that count, which was why it was allowed to proceed. That was the same issue in Jones, where they said where the individual supervisor is named in the count, then that can survive as a separate theory, as opposed to when you're alleging it against the corporate employer, and all the actions are alleged to be in the course and scope of employment, and there's no underlying tort alleged to have taken place, which was the issue in Axe. Axe was a situation where the retirement home was sued because employees had taken one of the residents to a former employee's house, and that former employee had been exploiting them. And in the claims of negligent supervision and training of the employees still working there, the court granted summary judgment or directed verdict on those negligent supervision claims because they said there's no underlying tort in those employees driving the resident to the other employee's house. The only tort they alleged was that that former employee had improperly and committed fraud and theft, and those were the underlying torts. There was no actual underlying tort of the supervising employees themselves, which is the same issue here. And for that reason, we ask that on the cross appeal, the court reverse and remand with instructions to enter a directed verdict in favor of Remington, and then ultimately a final judgment in favor of Remington, given the jury's finding of no liability on behalf of Henderson.
All right, thank you very much.